Hi, this is Josh Blackman. I'm the president of the Harlan Institute, and welcome to the 2021 Harlan Institute Ashbrook Virtual Supreme Court competition. This year, we're arguing the case of New York State Rifle and Pistol Club versus Bruin. We have our top four teams. We're in the round of four, and today we'll be arguing Campbell Collins and Gabrielle Lovins from Texas, and Arjun Kishore and Nicole Orlovsky from Connecticut. Petitioners, you have 10 minutes. Begin whenever you're ready.
May it please the court. My name is Gabriella Lovins, and along with my co-counsel Campbell Collins, I represent the petitioners, New York State Rifle and Pistol Association, Robert Nash, and Brendan Koch. The state of New York has denied petitioners' applications for concealed carry licenses under the Sullivan Act. This is unconstitutional because it has turned petitioners' right to self-defense into a privilege.
Would the court like a brief statement of the facts?
Please.
Robert Nash and Brendan Koch both applied for so-called unrestricted concealed carry licenses in the state of New York, but both of their applications were denied because of the proper cause requirement of the statute. And while that's not defined in the statute itself, surrounding case law has come to the conclusion that the proper cause requirement means that applicants need to demonstrate a need for self-defense distinguishable from that of the general public in order to receive a license. And even though Robert Nash and Brendan Koch had licenses for other purposes, such as hunting, they were not able to receive a license to exercise their core constitutional right of self-defense in New York.
The question presented today is whether the government may prohibit a law-abiding
Let's talk about this circuit split. What's the current split among the circuits with regard to public carry?
Well, Your Honor, in regards to this case, there is a circuit split on whether proper cause requirements are constitutional. For instance, one of the court cases that respondents cite in their brief, Peruta v. City of San Diego, has decided that the proper cause requirement in San Diego is constitutional. But there's a missing link there because the court in Peruta decided that they didn't need to decide the fundamental issue of whether the Second Amendment protects a right for citizens to carry weapons outside the home. And so the issue before the court today is exactly that.
Right, but I mean, are all the restrictions these various courts of appeals have considered the same? You know, I think Peruta is a California case. We have New York. Are all these laws the same? Or are there any differences in the laws that may affect the outcome of this case?
Well, yes, Your Honor, there was one difference in Peruta, and the procedural history is a little bit complicated, but the key difference was that when the case was first argued at the district court, open carry was allowed in California. But between the time of the district court and the appeal, open carry was banned in California, so that's no longer allowed. Whereas here in New York, open carry has been completely banned.
Is that the case though? Because I think the other side might say something different, that open carry might be allowed in some parts of New York, but not others. You want to just maybe speak to that for a minute? I'll ask your friends about it in a few minutes.
Well, open carry in New York is complicated, but it is mostly banned. There are some interesting permissions for open carry, such as antique rifles and long shotguns, I believe. But the basic handgun, which, as Heller stated, is the quintessential self-defense weapon, is completely banned from open carry. So the only way to carry it is through concealed carry, and you can't concealed carry a handgun unless you prove that you have a need distinguishable from that of the general public.
So are you, on your argument, counselor, is there a constitutional right to shall carry? Is that the only option that you think would pass constitutional muster?
Yes, Your Honor. Any sort of may issue puts too much discretion in a government official, and you should never have to earn your constitutional right.
What if we, I know you want strict scrutiny, I know that's your position. What if we go with intermediate scrutiny? Why would a shall issue regime not comply with intermediate scrutiny?
Well, Your Honor, intermediate scrutiny still places the burden on the government to demonstrate a rationale for why they need to restrict citizens' constitutional rights, which respondents still haven't done today. They cannot justify this licensing regime under either strict scrutiny or intermediate scrutiny. Now, the evidence that respondents have presented for this type of strict licensing regime in New York just simply doesn't meet their burden of empirically proving that this law does what it says out.
But New York argues that it's impossible to know in advance who might, lose their temper or lose their cool and use a gun for violence in public. Why isn't this sort of preemptive measure just a responsible public safety measure? So we're not forced to have some guy who's had a perfect record then just loses his cool and then starts shooting up the park.
Well, Your Honor, because no matter the public safety interest that New York has, they cannot achieve that interest by depriving citizens of a fundamental constitutional right. And that's what they've done with these licensing laws.
What limits do you think, under your argument, are constitutional?
Well, there's quite a few limits, such as training. Perhaps you have to go through 6 weeks of training, then pass the test. And if you're not satisfactory, you have to start all over again. Perhaps you have to see a mental health specialist and go through screening to prove that you don't have some form of mental health issue that the legislature decides means you can't have a gun. No felons can have a gun. Perhaps there's some extension where you keep guns out of people who have records of domestic violence. There's lots of ways this law, that public safety and gun violence could be reduced or curbed without taking guns out of the hand of the everyday person and turning a right into a privilege.
But what all of these permissible restrictions have in common is they aren't restricting guns from ordinary citizens with ordinary self-defense needs who are law-abiding. They aren't applying a standard that turns a right guaranteed to the people. And that's from Heller, that the phrase "the people" in the Second Amendment.
Right, but Heller just said heightened scrutiny. I think maybe how are you justifying this expansion from Heller of just heightened scrutiny to this sort of really strict tailoring? I mean, how do you bridge that gap?
Well, we know it's not rational basis, so we have to go up to intermediate or strict scrutiny. There's a lot of different analysis on this.
Maybe it's not scrutiny at all. Maybe it's text and history. And your friends on the other side look at the statute of Northampton, these surety laws. I think this at least suggests history isn't as clear as you think it is.
The statute of Northampton is irrelevant because it was effectively superseded by the English Bill of Rights.
Didn't North Carolina, at least some states, adopt it in its entirety in the United States, the colonies?
Well, yes, Your Honor, but even when they adopted it, there's no clear record of how it was enforced. And the evidence from the time of the founding suggests that it was interpreted not as a ban on all carrying, but as a ban on offensive carrying.
Heller said long-standing prohibitions. The Sullivan Law is over 100 years old. Isn't that pretty, half the age of the Republic, right? It's 100 years old. Isn't that long-standing enough for us?
Well, when we look at, no, Your Honor, it's not. When we decide if a law is long-standing and therefore presumed constitutional, we have to look at actually quite a few factors. First, was it in effect at the time of the Second Amendment? Second, was it in effect at the time
of the frozen?
14th?
If there was not a restriction in effect in 1791, we can never impose it. Is that your rule? We're frozen forever?
No, Your Honor. That's just not the only factor that we look to. Not all longstanding laws are constitutional.
We also look at, was open carry allowed when a certain concealed carry restriction was in place? Because if so, then the concealed carry restriction is probably constitutional. We also have to consider, was this law in effect at the time the Second Amendment was applied to the states, which was recently in McDonald v. Chicago. So this law was not in effect at those times, and therefore we can't consider it to be longstanding and therefore constitutional. It needs to be held up to strict scrutiny, which it fails. Now, when we look at strict scrutiny, we have to consider, first, is it the most necessary way to serve a compelling state interest, and is it narrowly drawn to achieve that end? And second, is it first, is there a compelling state interest? And then, is it the most necessary way to serve that compelling state interest? And is it narrowly drawn to achieve that end?
So the question today is whether taking away the ordinary citizen's right to bear arms is the only way to secure public safety in New York. Because if it isn't, it fails.
I mean, look, Counselor, there are different flavors of strict scrutiny, right? It's like Baskin Robbins, right? There are lots of different kinds. Do you need to show that that least restrictive means? Couldn't it just be one of many compelling ways? Why should it show it's the only way? That's not always the standard.
Well, Your Honor, that's because the right to carry arms outside the home is an extraordinarily fundamental constitutional right. It's right there in the text. The right to keep and bear arms shall not be infringed. So this restriction on the Second Amendment requires the same type of strict scrutiny analysis as other restrictions, such as on the First Amendment, because the Second Amendment isn't a second-class right. It should be analyzed in the same way as other constitutional rights. So in conclusion, we pray that this court will reverse the judgment of the lower court, render a judgment declaring the New York statute unconstitutional, and enjoin enforcement of the statute against petitioners.
All right, thank you so much. I think Professor Kelso might be in Zoom purgatory now, so we'll have to indulge his his iPhone. Respondents, please come on this camera whenever you're ready, and you have 15 minutes. All right, may proceed.
Chief Justice, and may it please the court. The New York state law should be upheld because proper cause requirements are constitutional. We would like to add a few aspects to the facts of the case presented by the petitioners.
Please. Yes. Go ahead.
First of all, we'd like to add that petitioners Nash and Koch appealed their permit decisions up through the law, and these decisions were upheld by Justice Richard McNally in January of 2018 and November 2016. We'd like to bring this up because New York's May issue gun permit regime has a system of judicial review in which applicants can appeal their decision up through various justices, and those decisions can be.
What's the standard of review when judges review the denial of the permit?
Well, the standard of review that the judges have is that they need to see a explicit reason enumerated by the officer as to why the applicant was denied, which is to say the law itself specifically prohibits any arbitrary application.
Right, but if the official says, I did not think there was sufficient cause because their need was the same as everybody else's, right, in society, that would be enough, right?
If they cannot enumerate, if the applicant cannot enumerate a specific reason as to why, then they typically would be denied under this regime. That's correct.
Right. So, I mean, we're not challenging. I think that the judicial review aspect is fair. I think they're challenging whether the standard itself is not. So proceed with your argument.
The next aspect of our argument we're going to go into is the review standard, which we believe should be intermediate scrutiny.
We believe that the review standard in this case should be intermediate scrutiny because the presumptively lawful measures established in Heller are incompatible with the strict scrutiny standard, and because the state of New York in this case reaches the barrier needed for intermediate scrutiny in having narrow tailoring and a compelling government interest, or a substantial government interest, at least in this case. We would assert that under intermediate scrutiny, we win the case because our—
Do you, Counselor, if we review this with strict scrutiny, do you lose?
Your Honor, under strict scrutiny, we believe that we would also win. The barrier for strict scrutiny—
Okay, so we gotta talk about this. How do you guys show narrow tailoring? This is the most strict regime in the country. There are 40 something other states that have a more permissive regime.
Your Honor, the reason that this is narrowly tailored is because of the precise government interest that is being protected here. In terms of protecting public safety to the same degree, there is no regime that is as effective.
Right, but
Your Honor,
40 something states have done a different approach. How can you say this is the least restrictive means? It seems a pretty bit of a blunderbuss, if you ask me.
Your Honor, when looking at this case under the scrutiny standard of intermediate scrutiny, you would look at if the government's objectives are reached in a way that is not substantially broader, and we would assert that in reaching the government's objective of promoting public safety, there is not a way that they can implement the law more broadly. If they implemented, say, a shall issue regime, their interest in promoting public safety or this compelling government objective would not be achieved in the same way because you would have more gun deaths and casualties under a shall issue regime.
Right, but again, we're talking about least restricted. Isn't there some other way that you could achieve your interest other than a complete good cost standard? That seems really broad.
Well, Your Honor, what's important here again is in order to achieve the same level of a government interest, we agree that shall issue regimes exist in other states. However, as we've mentioned, it does not protect public safety to the same degree. And this has been empirically proven. As we talk about—
Well, I get that those are the effects of the policy, but scrutiny asks, okay, you have a government interest, right? Public safety, fine, right? But in terms of narrow tailoring, isn't there something you could do? Your friend on the other side said mental health checks, firearm proficiency training. So she listed like 5 or 6 different things. Why wouldn't those be least restrictive means short of a complete, shall issue with no restrictions?
Well, Your Honor, the key reason that does not that our regime still reaches this standard is because the majority of cases and the majority of issues that prop up under shall issue regimes are not weeded out through the application process, which is to say they're first-time offenders. They have no obvious aspects that would be weeded out through background checks, et cetera, et cetera. So in order to achieve a regime, or in order to achieve a state where everyone armed with a weapon will
How does a good cause standard actually weed that out? Don't people with good cause still lose their tempers, lose their cools? I mean, I don't even see how the standard you have actually prevents someone from losing their mind and going crazy one day just because they have a good cause at one point in time. That how does your rule actually achieve your goal?
Yes, Your Honor. So the good cause standard, one element of it is the applicant demonstrating good cause. However, in the application process, there are other elements as well, including an investigation by the FBI and the local sheriff's or police commissioner's office.
No one's challenging the
health.
background checks. Your other side, they're not challenging. All they're challenging is the good cause standard, right? How does having a good cause standard actually prevent someone from losing their mind and engaging in acts of violence? I don't see how your actual means chosen accomplishes your constitutional end.
Well, Your Honor, the reason that this happens is because, again, they have to show an explicit reason. And on top of that, under this regime, it is typically evaluated the individual's skill with the weapon, which is to say that applicants who demonstrate, of course, there can be small isolated incidents where one person could lose their mind. However, we believe that this regime weeds out the vast majority of those situations. And that is proven by the fact that this regime has shown to statistically be far safer than any other regime in the country.
Isn't the problem with your approach the notion, I mean, you're talking about a fundamental right, which means you presumptively get that right unless the government has some particular reason for restricting it. You're flipping that burden and saying you presumptively don't get a gun unless you can make a specific showing. Isn't that the constitutional problem with your approach?
Well, Your Honor, there's two reasons why we believe that this logic does not hold. First of all, is that the exercise of this right is not blocked. We would note that this is separate from keeping and bearing arms in the house as well as in the car for self-defense purposes. But second of all, we would also note that inherently in the Second Amendment right, there's a long history of restrictions. Of course, the Justice Blackmun mentioned earlier the Statute of Northampton, but we'd like to point to colonial and US regulations that have historically regulated this right. The petitioners themselves mentioned that there were not examples of restrictions or regulations at the time of the founding, but we contest this notion. In our brief, we specifically mentioned 3 late 17th century gun restrictions in public spaces by New Hampshire, New Jersey, and Massachusetts. We would also note that proper cause itself is a long-standing restriction. The first example of proper cause was the 1836 Massachusetts Act, and proper cause henceforth was a standard in many areas of the country. So fundamentally within the Second Amendment, there is this idea of states having the ability to regulate in the public square. And for that reason, we do not believe that the Second Amendment right is impeded by regulating the public square.
But let's I want to talk about strict scrutiny just for a minute. In terms of narrow tailoring, though, let's say we agree with you on history, right? But in terms of narrow tailoring, very few laws survive strict scrutiny. I can count on maybe one hand the times where laws survive strict scrutiny, right, by the Supreme Court. Do you have a fallback position that if we think on strict scrutiny loses, there's some other regime that you'd be willing to accept that you might be willing to entertain? Because let's say we don't agree with your strict scrutiny answer.
Well, Your Honor, we still believe that strict scrutiny works. However, an alternative regime that would not achieve the same level of interest would be a heavily restrictive shall issue regime. That's the closest analogous.
What would that look like? Yeah, maybe Mr. Orlovsky, just we bounce that. What would that look like?
Yes, Your Honor. So that would look like with a shall issue regime. Under a shall issue regime, you have specific requirements that need to be met. And under those requirements, the state has to give you the permit. So under a more restrictive shall issue regime, you would just see a larger list of requirements, maybe more.
Yeah, your friend on the other side mentioned about mental health, et cetera. Would that be what you're basically advocating or what you're discussing?
Your Honor, that could be what we're advocating. However, we would not want to delve so much into specifics of that, as we believe that the legislature in New York state should be able to decide the specifics of this given the system of federalism.
So if
They
we,
should
if
have
we
the
declare, if
latitude.
we declare the New York rule unconstitutional right now, does that mean New York can start issuing permits, tomorrow?
Well, Your Honor, of course, they issue permits currently.
No,
but
I
we
mean,
do-
if we declare that the law is unconstitutional today, does that mean tomorrow Coach and Nash can go in and get the permits?
Your Honor, it may take a while because of procedural reasons to maybe get this to be in place, but if it was declared unconstitutional and it was replaced by another regime.
Well, I mean,
such
that's
as
not
the
how courts work. I'm asking, so courts say the law is unconstitutional, go figure it out, right? What does New York do in response?
Well, Your Honor, we believe that if you are to strike this down, of course, we mentioned a restrictive, a more regulated shall issue regime. However, we also believe another option would be a regime in which the state can enumerate an explicit reason why they deny law-abiding citizens, which would effectively be the flip side of the current New York regime. Now, again, we still do not believe that this achieves the same government interest. And this also goes against, as we've mentioned, over 100 years of precedent for states to regulate in a proper cause way. However, we believe that that regime would still be better than a shall issue regime at upholding and protecting public safety.
In our first argument regarding federalism, we assert that states reserve the rights to make these laws. We see a long-standing tradition of states being given the latitude to regulate regarding certain fundamental rights, including the Second Amendment. The Bill of Rights was intentionally made to limit the powers of the federal government in certain ways and to ensure that states could have latitude legislating, because, as we've said in our brief, there is not a one-size-fits-all approach to legislating about the Second Amendment or other fundamental rights for that matter. In the late 17th century, as my co-counsel mentioned, states like New Hampshire, New Jersey, Massachusetts all place restrictions. So it's important to have discretion when regulating with the 10th Amendment and making sure that there's no national decision-making on this fundamental right, as we do not extinguish the core of the fundamental right, rather we regulate regarding certain aspects of it, and we make sure not to extinguish the core because citizens can still exercise that right within their homes, off-road backcountry in their cars,
So
etc.
let's talk about open carry for a bit. I know there's some disputes. What's your position with regard to open carry in New York? How do you
Your
understand
Honor,
that record?
Your Honor, with open carry in New York, the New York penal law does not specifically address open carry. However, it is essentially not available in New York because they have not legislated on it.
So at this point, it's not an alternative to open carry in New York. That's your understanding.
Yes, Your Honor, that's correct.
What if the court says there's actually a constitutional right to open carry? Would New York, what would New York do in other words? Would New York say, okay, yes, you could open carry but not conceal? Would you say, oh, we'll let you conceal but not open, right? What would New York actually do in response?
Your Honor, open carry often requires a higher level of regulation under laws in general, under the Second Amendment, because it has a larger safety risk and more of a threat in carrying the weapon. Also, there would probably be two different regimes because the application process for open carry versus concealed carry could be different. So we're not sure exactly how New York would respond in this case, but it could be two different situations based on the two different kinds of carrying.
We also believe, Your Honor, that open carry has a much more higher historical regulation as well, going back to the idea of offensively armed regulations. Those regulations have existed for hundreds of years, and in that vein, open carry would fall under being offensively armed. Of course, this goes way back to orders in 1219 from Edward I, but there's also a long history of states doing this. For example, the 1795 Massachusetts Act, New Mexico laws in 1895, Delaware laws in 1852. So open carry would be should be far greater regulated because of the long history of regulations from states.
I want to make sure I give Justice Kelso a chance if he has any questions. He's on low technical problems. Any questions, Justice Kelso? You vanished. Justice Galloway, questions? I will give over a chance. Professor Justice Kelso, you back? You have any questions, Justice Kelso?
Whoops.
Okay, Justice Galloway, you have a question? I'm sorry, we're having technical difficulties.
Sure. The justification for your law is largely dependent on, the public safety and the designation of the sensitive area. What guidance do you have for the lower courts in determining, some sense of what a sensitive area is?
Well, Your Honor, we believe that sensitive areas are small in specific locations that have that incredibly high heightened need of security. The reason that we specifically mention it is a small areas because Heller itself outlines that sensitive places cannot be large, statewide or entire cities. They have to be individual buildings, individual properties themselves. So for that reason, we think sensitive places fall entirely separate of this debate because, again, it has to do with enumerating a specific location that requires that heightened need rather than the general public or a city having that need.
Well, let's talk about New York City. Give me some examples of what sensitive areas would be.
Your Honor, an example of a sensitive area would be, for example, a public school.
Churches,
What about the subway?
subways, to our understanding, I see our timer has elapsed. Maybe finish.
Yeah, you may answer the question, but
Subways generally would not contest under sensitive places because of the vast area that they occupy. Subways and subway stations are so enormous throughout New York City that would be the vast majority of the city itself. So for that reason, under Heller itself, that would not constitute a sensitive place.
okay. Thank you, Counselor. Your time is up.
Thank you, Your Honors.
Yes, thank you. 5 minutes for petitioner, please. Begin whenever you're ready.
It please the court. We would like to address two arguments made by the respondents. First, scrutiny. The proper level of scrutiny is strict scrutiny, and the government has not met their burden of proof. And second, government interests cannot eliminate rights.
First, the burden of scrutiny. Now, because this law deals with a fundamental constitutional right, the burden is on New York to demonstrate why this right furthers an important government interest in the least restrictive means possible. So New York needs to show empirical evidence that this law achieves the end it sets out to, which the state has not done.
Respondents cite quite a few studies saying that places with shall issue licensing regimes have higher gun violence. The issue with these studies are that we have studies saying the exact opposite. So clearly there's a conflict here.
But if there's a conflict, shouldn't the presumption go to democracy? Shouldn't we just give the tie to the legislature to make these decisions?
Well, no, Your Honor, because when the legislature is restricting fundamental constitutional rights, rights that are protected within the Second Amendment, they don't get discretion to abridge citizens' rights based on perceived but not proved results and perceived but not proved government interests.
So the state has failed to prove that their law achieves the compelling state interest of public safety. Therefore, it fails that prong of the strict scrutiny test. So once again, we move to the second prong. Is it the most necessary and narrowly tailored means possible?
So which exact flavor of strict scrutiny we need? I asked your friends this. Is it the least restrictive means or narrowly tailored? I mean, how strict is this strict scrutiny that you're asking us to follow?
Well, because this law is comes so close to the core of the Second Amendment, the right to carry arms outside the home, it really does need to be least restrictive means. However, it would fail any flavor of strict scrutiny, and it would also fail intermediate scrutiny because it is just so restrictive on citizens' rights without empirical proof of its efficacy.
Okay, Justice Kelso, I know you're having some technical issues. Do you have any questions? I think he's shaking his head no. Okay, he keeps pumping, but he messed with me. He can hear everything you're saying. Justice Gallo, any questions?
Yeah, I tell us where to draw the line. I mean, what is it that you are asking this court to do? Help us write the opinion. What is it that you're asking the court to rule?
The court needs to rule that a proper cause standard, which does not include the basic need for self-defense, is unconstitutional.
Because that type of standard turns a fundamental constitutional right into a privilege. So while citizens may lose their Second Amendment rights, they can't be forced by the legislature to earn those rights, which is what the licensing scheme in New York does.
Laws such as taking guns away from felons are legal because you can lose your Second Amendment right, but you never have to earn it. The state of New York is asking you to earn your constitutional right by proving that you have an exceptional need for self-defense.
And that's unconstitutional because the Second Amendment applies to the people, not an unspecified subset of the population, such as the unspecified subset of people in New York whom licensing officers believe have enough
How do we,
need.
but I mean, look, I mean, Counselor, I get all your arguments, but the government's here telling us that people will die, right? We're looking at potential deaths. And how can the court use these sort of constitutional abstractions about 200-year-old documents to stop the state from saving lives? How do we square that? I'm having just difficulty with that answer.
Well, Your Honor, the question is not how many people die, because one unnecessary death is too many. The question is whether New York can draw a direct line between this law and preventing those deaths, which they simply cannot do.
Now, when we're looking at what kind of compelling state interest is compelling enough, one of the things to remember is that there is no interest compelling enough to remove a right. If the American people decide that guns are too dangerous and no one should be able to
Didn't
carry
New
them,
York do that? I mean, didn't New York's legislators elected decide that these guns should be banned?
Yes, and that is the problem. Because
The people are the problem. The people of New York are the problem.
not quite, Your Honor, the legislature is the problem.
Oh, but they're elected by the people. They're elected by the people. New York is
We have a channel for amending the Constitution. You can put in a
you finish your answer. You're over time. You finish your answer.
Yes, Your Honor. So we have a method of amending the Constitution. What the legislature has done has taken that into their own hands and passed a law to amend the Constitution, and that's unconstitutional.
Okay, thank you. Your time's up, Counselor. Okay. If the other team can please come back on camera. I'm sorry, that was a little from the last second. I'm sorry. That was really impressive. I know Professor Kelso said he heard it. I know his Zoom was in up, but
Yeah,
I heard it.
Can you hear me now?
Yeah.
Can you hear me now?
Yeah,
Okay, I finally figured. My phone was on. My internet went down on my computer, and I had to go to my phone. I heard all the arguments and saw the video, but it was in a safe car mode, and so it wouldn't let me talk, and I didn't want to mess around with it.
Oh no.
So I didn't want to lose the video and oral, but I finally figured out how to do it, so now I can talk.
Okay, that's great. Well, thank you, Professor Kelso.
But I saw the whole argument. I saw all the video of the argument.
Oh, great. Let me give some feedback, and I'll turn to my colleagues in a moment. I've judged you now, I think 3 or 4 rounds, and I can tell you each level you're bringing your intensity up, but also we're dialing out the pressure up each level, and that was really impressive. Both of you have very good courtroom demeanor. I think you were mature. I like when answer a question, you answered yes or no, or you sort of rephrase the question right away. That's a skill that's not obvious. That even law students sometimes have difficulty doing that. But like, I threw questions like yes, Your Honor, no, Your Honor, however, yes, but, no, but. That's good. And sometimes you sort of rephrase the question, maybe rephrase it slightly, which is okay. Because Nicole did that a couple of times. I noticed. I noticed it was very subtle, but you're there. Both of you have very good teamwork, right? In law school, it's one at a time. High school, they do too. I don't quite understand why, but you like it better. But I thought the rapport between 1 and 2 was very good. You smoothly handed off. I didn't feel like you were fighting against each other. You've practiced, obviously, these transitions. I can tell you practice it because it's done there. You sort of took our insane questions and you didn't attack them. You sort of took them for what they're worth. I asked you about circuit splits. You gave me what the different circuits are saying. That was strong. Asking you about history, you're giving history. Curious choice with the respondents. You're defending on strict scrutiny. And I think you sort of held your ground. I mean, I don't, if I was in your position, I would probably have conceded it, but I think you held your ground pretty strong. There, even in strict scrutiny, I mean, it's probably a losing argument, especially with this court. Professor Kelso might agree with me on this one, but you at least sort of, you dug your feet in and you tried to make it. I think you did it well. I think your presence was good. Even over Zoom, I could really see that you're connecting with the camera, you're looking right at us. And I just continue to be impressed. These are 16, 17-year-old kids, and they're doing the work of law students. So it's awesome. Now, your coaches, your judges, Professor Galloway is the coach of our top-ranked moot court program, and so I'm always eager to hear what he thinks about the performances.
I thought y'all did a terrific job. You were responsive. You directly answered the questions and then told us why, which is always what you want to do, because what you're doing when you're talking to judges is you're trying to help them write the opinion. And you have your own perspective of how the problem is put together. But when a judge is sitting there asking you questions, you're dealing with their perspective of how, how they approach and see the problem. So the most important thing is to connect with the answer to the question and then explain why. And you did that very well. One of the other things that I was really impressed with on both sides was the level of detail that you added in your answers, because you just didn't give us conclusions, you gave us specifics. And when judges are writing opinions, those specifics are what really drive the analysis and explain why you're right. So keep doing that. It's terrific to tell us, like, New Hampshire does it this way and Virginia does it that way, because those are the things, one, that are interesting and are engaging, but they also make your point. And it's really impressive. It shows that you've done your research and you know what you're talking about as well. But y'all are terrific. And it was really an honor to listen to you argue today.
Thank you. That means a lot to hear. We really love the competition.
Professor
Thank you.
Kelso?
Yeah, I apologize for my computer thing, but I only missed maybe 30 seconds of the petitioner argument before I got on my phone. And I say it was in safe drive mode, so it wouldn't let me talk or whatever. But fortunately, Rob asked a bunch of the questions that I asked in the first round. And so he sort of picked up on the kind of questions I was asking anyway. So I think the two rounds were relatively similar in terms of the hot bench and the questions both teams got. And I think you guys did obviously did a great job. You're well prepared on the issues. And it's, this is a good problem in terms of the existing law now, because the existing law now is there are some splits among the Court of Appeals about how stringent the scrutiny should be in these cases. Supreme Court's got this case before it. And I said to the first teams, and I say again, it seems to me it's clear the Supreme Court's are going to strike down this law for sure. The only question is, are they going to have a broad opinion saying, and it's all strict scrutiny for all these kind of cases to make it difficult for all states to really regulate open carry? Or are they going to have a more narrow approach saying, well, even under intermediate review, this law is still substantially broader than it needs to be. Because this New York law is on the far end of what states are doing. And so the Supreme Court's going to strike it down. The question is, will they strike it down with a broad opinion, strict scrutiny that really raises questions about lots of state laws, or will they just say, no, this New York one is just way too broad, but still give some other states flexibility to have maybe a more narrowly tailored law? But for purposes of your moot court today, that hadn't happened yet. So this is still a great problem, arguing sort of sensible arguments on both sides. Should it be strict scrutiny or should it be intermediate review? And I thought you guys did a pretty good job articulating all the issues that are related to that. So I was very impressed with the argument.
Awesome. Questions for us. What do you want to ask?
Well, first of all, I'd like to start, of course, saying thank you, Professor Blackman. We've really enjoyed this competition so far. And of course, Professor Kelso Galloway for volunteering your time. And obviously, great job to the petitioners as well. My question was regarding federalism and how you sort of contextualize federalism within incorporation. So if, like, for example, any right that's been incorporated, how do you sort of read the berth that states have granted under federalism?
Randy, you want to answer that one? Maybe you make a different answer than I will, but that's...
Well, the official Supreme Court doctrine is, once a right is incorporated, you use the same level of scrutiny with respect to federal legislation or state legislation. So there is states don't get any greater federalism right once a right's been incorporated. Now that's the official doctrine. In looking at how they actually decide cases, you can sometimes, think that maybe they're a little more sensitive to issues of federalism when they're dealing with a state law rather than a federal law. But they don't say that. The official doctrine is it's the same level of analysis, same level of scrutiny, same level of rigor, because once it's incorporated, it's just that right. That federal right now applies to the states in equal amounts. in terms of making arguments to the court, you can't phrase it really as federalism. You can talk about how, and sort of, should courts be making these decisions, or should there be some deference to the legislatures? But the level of deference should be to both state or federal legislation regarding gun control, as in this case. And you sort of make that argument that we ought to give states greater leeway, just as a matter of general deference to legislative policymaking. Yeah, but you can't really argue federalism on that somehow the constitutional right is.
Oh, no. Okay, thanks. Any questions from Ella or Campbell?
I don't think so.
I don't
All
think
right.
so
I'm
either.
sure I'll come up with something at midnight tonight.
That's fine. Well, I want to give you the same invitation. If you're ever in Houston, perhaps easier for Gabrielle and Campbell, come on by to South Texas. We'll have to give you a tour. Rob is the coach of the advocacy team. I'm sure he'll let you meet with some of the students and just chat with them. They're always sort of hanging around his office, eating his candy. So it's always fun. But you guys are really on your way. You're in high school, but you're performing at the level of law students, and it's frankly impressive. The championship round, I mean, the date we put on the announcement is April 25th. It's gonna be in DC. We're gonna do it in person at Georgetown. So we will announce, I think later today, which team will be advancing. So I wish you good luck. I don't know the answer yet. We gotta confer, but so if you have other questions, the students can please sign off. I'll talk to the judges for a bit, and we'll be in touch very soon about the next round. But I want to say congratulations to you. I know Mr. Hull. If you want to come on the camera just for a minute, Aaron. He's been coaching teams for many years. Has done a great job. And also, Gabriella, is your parents there? Are they there with you?
We have our dads who are
Yeah,
on the
come on
coach-
camera. Just I always like to give recognition to the coaches, because the most important part of a team is often the people who are coaching them. Hi, Gad. Okay.
Hello.
You guys are be very proud. Aaron and dads, you should all be very proud. Your students are doing such a impressive job, and they're really on their way. They're on their path to achieve great and profound things. And I can't wait to see in 3, 4, 5, 8, 10 years where you guys wind up. You'll be arguing for appellate courts around the country. Maybe we'll be on the court, maybe on the bench one day. You'll be saying why. I can get to criticize your opinions then. It'll be good enough. All right. Thank you both. I'll say good farewell to the students. Aaron, take care. Good
Thanks.
seeing you. And let's chat with the judges.